Can a drag queen parody a billion-dollar apparel company's trademark for her name? Here's a trademark lawyer's take on the Patagonia versus Pattie Gonia dispute. So, if you didn't know, popular drag queen Pattie Gonia has been using that name for several years, building a sizable following and doing a large amount of environmental advocacy work. Patagonia surely knew about her use of the name, but only recently has filed a lawsuit claiming that Pattie Gonia is infringing on their trademarks. Here's the kicker, they're only asking for $1 in damages. Of course, what they aren't saying as loudly is that their complaint also contains a demand for repayment of legal fees, which, if the case goes all the way to trial, could be 6 or 7 figures. The case is really interesting from a trademark perspective because it touches on a complicated point in trademark law, parody, and free speech, and is actually very similar to a recent case decided by the Supreme Court. Now, the threshold test for a parody defense in trademark infringement comes from a case called Rogers versus Grimaldi. In short, the court ruled there that an expressive work, like a movie or a TV show, can parody a mark as long as it has some artistic relevance to the underlying work and doesn't explicitly mislead as to the source or the content of the work. Now, recently, the Supreme Court tackled a similar case to the Patagonia dispute in Jack Daniel's versus VIP Products. Jack Daniel's sued the manufacturer of a dog toy because that manufacturer made a chew toy that looked very similar to a bottle of Jack Daniel's with the mark Bad Spaniels. Now, the Supreme Court ruled unanimously that the Rogers parody defense didn't apply where the use of the Jack Daniel's trademark was a source identifier. So because they used the mark as the name of the product rather than some element of a creative work, the parody defense was no help. Now, given that ruling, Pattie Gonia will likely face an uphill battle if she tries to assert that same parody defense, but her answer to the complaint does have some other asserted defenses, like waiver and laches. If you want to hear more thoughts on the case or have other questions about trademark law, leave them in the comments. And as always, make sure to follow GearhartLaw for more intellectual property news.